Good evening, everybody. It's 6:02 on Monday night. I've got a little bit of time here. I want to talk about the Bond County real estate tax stuff because I'm actually headed to the 4-H auction at 7 o'clock here in Bond County because I go to the 4-H auction and buy something from one of the kids that have worked on those all year. So I'll try to go as quick as I can. Again, this is for the Bond County real estate tax case, so please don't be typing about gun stuff over to the right, etc. I know you guys like to talk about that, but I'm not going to pay any attention to any of that because that's not what this is about, okay? This is about Bond County, Illinois, and their real estate tax issue that we got going on. So on or about July 25th, many of the people in some of the townships got new assessment notices, okay? Got new assessment notices, and you've got 30 days to file an appeal with the Board of Review, plus there's other legal options you can take too. You have to decide whether you're going to do that or not. We have a bunch of people that have asked us to help them. I'll talk about that a little bit more lately, but you don't have to have a lawyer. You can try to do it yourself. You can go hire anybody else in town or out of the area, Pat Schaufelberger, Kevin Seibert, Trent West, Ryan Connor, all of those men, they know what they're doing if you go ask them too. So this is just try to help you understand it. So again, for those of you that got new notices on July 25th, that's what we're going to kind of talk about, okay? All right, Ryan. All right, so as I've told you before, the taxation of your real estate is grounded in the Illinois Constitution from 1970. Most important thing is it says that your property, your real estate, has to be taxed uniformly as required by the law. Uniformly means they got to treat you fair. They got to treat you like every other taxpayer. So if you think your taxes are too high, as long as all your neighbors' taxes are the same amount too high, that's uniformity. So if you want your taxes to go down, there's things you can do. But what I'm talking about is making sure that you're treated fairly right now and that you procedurally go through the process correctly if they've done something wrong in the process, okay? Whether your house is brick or shouldn't be brick or it's got too many bathrooms, all of those little issues of value is not what I'm talking about. I'm talking about the process of which they have given you notice about a change in your assessment and whether that was done rightfully or wrongfully as compared to your neighbors and is required by the law. Make sense? Okay, Ryan. All right, general assessment years. You need to understand what is a general assessment year. A general assessment year means for towns less than 3 million people, which is us in Bond County. It's every county in Illinois except for Cook, where Chicago's at. They have a different set of rules. Sometimes that makes sense, and in this circumstance, it probably does. So Bond County, general assessment years every 4 years. What that means is that if you're not in a general assessment year, they cannot change your property based upon fair market value fluctuations. If the assessor thinks your property has just skyrocketed in value, they can't change it unless you're in a general reassessment year, simply speaking. Now, if you've made additions, you've added a big building, you've added an addition, they can increase it. But if leaving that aside, it has to be a general assessment year if you're getting a market value change. And it can only happen once every 4 years. So the question you should be asking yourself is, when is that general reassessment year? It's a very important question. Is it a general reassessment year for me? As you can see in this provision of the law, it started in 1994 and every 4 years thereafter. So just so you don't have to do the math, 2019 was a general reassessment year. 2023, the year we're in right now, is a general reassessment year. So by default, your property could be increased for 2023 if you are in a 4-year quad scenario. 2022, which was last year, which many of you got those notices for, was not a general reassessment year based upon this provision of the law. You with me? I'm trying to keep it as simple as I can, but under the default provisions of the whole county gets done every 4 years under this provision of the law, it would be this year, 2023. It would not be last year, 2022. Okay, Ryan. Now, there is a provision in the law that says that a county can break the county up into 4 general reassessment districts. If you don't do what we have here, then every 4 years, being 2023, last time was 2019, the whole county had to be reassessed uniformly. Remember what the Constitution said in that year. Every property in the county, there's 14 to 16,000 properties in little old Bond County. So they'd all have to be done 2019, 2023, unless this resolution was passed changing it into 4 general reassessment districts. The question you should be asking yourself is, did Bond County properly break up our county into 4 general reassessment districts? Yes or no? If they did not, then you can't be reassessed in 2022. You can only be reassessed in 2023 based upon fair market value, because 2019 would have been the last time by default. Did they properly break our county up into 4 general reassessment districts anytime in the past? Okay. Now, the answer is no, and I'm going to explain to you why. They have not prior to this year. So again, we're talking about prior to 2023. They had not redone the county into 4 general reassessment districts. They tried and they messed it up. Go ahead, Ryan. Okay. Here's a resolution that they tried to pass back in 2020, breaking the county up into general reassessment districts. Remember when I told you that under the default rule, the whole county is every 4 years? And it told you it starts in this particular year, 1994. That way you can come forward and you always know, you as a taxpayer have notice of when I could potentially be reassessed. That's what that law did. So the law also says that if they're going to do this with the resolution and break it into 4 districts, this resolution has to explain to you as a taxpayer when your property is going to fall in what year, because they have to do it by townships, and they have to put in this resolution. This year we're going to do this townships. Next year we're going to do this townships. Next year we're going to do these townships, and in the 4th year we'll do these. And over the course of that 4 years, they have covered everybody. So instead of doing them all in 1 year, they do about 25% in each of the 4 years. This resolution has to explain that schedule to you, because that's how you as a taxpayer get notice that you're up in a particular year and could be subject to general reassessment based upon market value. This resolution does not include that information. If you look at it, it doesn't say what assessment districts 1, 2, 3, and 4 are, nor does it say which townships are which in assessments 1, 2, 3, and 4. They screwed it up bad. And you know how you know they screwed it up? 1, because I'm telling you so, and you can look at the document. And 2 is they just tried to fix this last week. And to the extent they may have been able to fix it, it only goes forward into future years. They can't go backwards into the prior 4 years that's been screwed up. You with me? Okay. There's a resolution to your left here, and it's 2 pages, but Ryan put up here, this is what they just passed on August 1st of this year, so a few days ago. I guess a week ago tomorrow. You see where it says Assessment District 1, Assessment District 2, Assessment District 3, Assessment District 4. You see that? This at least technically may be a proper resolution going forward into the future. It doesn't fix anything going backwards. This document, guys, I'm telling you, is an admission that they screwed up the last resolution, which means that you're not able to be subject to general reassessment in 2022 for your properties. You with me? That's a legal argument that you can say, you can't assess me in 2022 because you never properly broke the county up into quarter quads. It's a legal argument. It's a very good legal argument. Chances of winning it in a courtroom are high. Okay. I never say guaranteed because we're lawyers and we always hedge, but I'm telling you, it's high. Anybody that knows anything about real estate law would know that. Go ahead, Ryan. Okay. This again, going back to the general reassessment year notice that I was telling you about before, it says in there of what they have to do and how they break it up into the districts. And once they divide it up into those districts, they have to go and they have to actually visually inspect every property. They have to look at the properties by June 1st of that year, and they have to give everybody notice of what your assessment's going to change if you're in a general assessment year, okay? You have to look at them personally and physically inspect them by June 1st. They have to get these notices prepared, the notice in the newspaper, the notice that you get sent, and they have to send those to you by a particular time to give you time to object if you want to object. Go ahead, Ryan. Make sure I can read that. It's getting kind of small. I'll have to lean up close. Okay, this is what's talking. I'm not going to talk about this one much. This is about in non-general reassessment years. And I'm telling you, 2022 in Bond County was not a general reassessment year. It was a non-reassessment year, which means they can't adjust you to fair market value. They might add an equalizer, everybody across the board gets increased or decreased depending, but they can't do individual market value adjustments. That's what it means in a non-general reassessment year. And the question that you ask yourself, in 2022, was my house in a general reassessment year or a non-general reassessment year? The answer is non-general. I don't care what they tell you, okay? Because they screwed up that resolution that I was telling you about. So if you were in a general reassessment year, as I've told you, you have to get a notice. This is a completely separate issue. And go to the next one, Ryan, talks about the notice. Publication of assessments. Do you see that? You see that statute? I'm going to come back to that in a second. You see where it says 35 ILCS 200/12-10? That's a provision of the law that talks about, okay, if you are in a general reassessment year and you are going to increase taxpayers' assessed values based upon a fair market value determination, you got to tell them that you're going to do that so they can have a chance to object. This is the part of the law that says that, okay? Then you go down and you see where it says, when do they have to publish that? It says the publication shall be made on or before 12/31 of that year. See that? I'm going to jump over here a second. Mark, how can they raise my taxes after they closed our school? That's not a legal procedural question. That question there, my friend, is why they get away with doing what they're doing. I'm trying to explain to you a very specific legal argument of how you can contest your taxes if you are in this position. Talking about policy issues of whether they should have closed our school or not closed our school, or how can they raise taxes when they can close our school, that's getting way off on a tangent, my friend, that's never going to help you. That's a conversation to have around the kitchen table because it's a good question policy-wise. They're still raising taxes after they close the school. Of course they're going to do that. And we can have that conversation. This is about procedurally how you can defend yourself. Okay? Thanks, brother. All right, go on. So Ryan, not yet. Guys, the notice that they have to give has to be done by 12/31 of 22 for the 2022 tax assessment year. They're trying to modify your taxes for 2022, not 2023. George is a year late, has been a year late for 4 years now. The statute says by 12/31 of the assessment year, 12/31/22. Okay, go ahead, Ryan. Here, I'm going to give you a couple of examples. This was the notice that Georgia put in the newspaper. Just for when I say Georgia, I'm talking about the assessor, Georgia Schenck. I've known Georgia for over 30 years. I don't have any personal animus against Georgia, but she's an elected official in this state or in this county, and this is a state office kind of. In this county, she has a job to do, and if she doesn't do the job right, she has to acknowledge it and try to fix it, not cover it up. And whether I like her personally or not doesn't change that. This is the notice, you guys, for 2018 taxes that I wanted you to see. This is the last notice that was done legally in Bond County as it relates to assessments. You see the date at the top, September 18th, 2018? That's for your 2018 taxes that were done that year and some changes were made. Now, there's issues going on here, but I don't need to talk about them because the point I want to make to you is that this was published before 12/31 of 2018 because the law requires it. Go ahead, Ryan. Here's the one from 2019. Look at the date, April 23rd, 2020. This is the first year that Georgia messed this up significantly. This notice was entered in April of 2020, attempting to give you notice of changes of tax assessments for January to December of 2019. So 2019 tax year notice had to be done by 12/31/19. They didn't do it until April of 20. This notice was invalid. Every notice since this 2019 tax year, 2020, 2021, and now 2022 that we're talking about are all invalid because they were not timely. Go ahead, Ryan. Here's the one for 2022 that all of you just got recently. You got this on July. This is the first one. They sent out two and they screwed them up. And I'm going to explain to you why they screwed them up. This was the first one you got on June 23rd, 2023. A couple of things I wanted you to point out to you. Do you see up at the top, come down about, I don't know, a couple of inches where it says valuation based on sales from 2019, 2020, 2021. Do you see the 3 years that they're using there of sales history? You see the multiplier there of 1.174%. That's 17.4%. Georgia is trying to tell you that everybody in the county that didn't get generally reassessed to market value got a equalizer of 17.4% because according to the sales history for 2019, 20, and 21, she had to raise everybody 17.4% to make sure that we're within 33 1/3. Okay, because 33 1/3, 1/3 of your fair market value is where assessments are supposed to be. And so Georgia's trying to say to you, I added 17.4% to everybody because for the last 3 years, we've been underassessed as a grand proposition countywide. And then the next thing I want to point out to you is she's telling you that this publication is being put in the newspaper under the law of 35 ILCS 200/12-10. I'm going to come back to that. So Georgia's saying, look, I'm giving you this notice because the law says I have to, and this is the reason that I have to do it, and this is the equalizer that I'm adding as well because that's what the law calculates. Go to the next one, Ryan. She made a couple of mistakes that I'm not going to talk about, and she had to issue a new notice to you guys. 7/25/23 is when you got this new notice from Georgia. So one of the ways you have to appeal, that date's important because you'll have until August 25th to go to the Board of Review in Bond County. But to do this appeal effectively, you're not just going to want to do the Board of Review. You're also going to want to go into the court and pay taxes under protest. That's two different strategies. But this notice that you got on July 25th also says that you got a 17.4% multiplier or equalizer. It gets used interchangeably sometimes. Equalizer that everybody in the county got, except for those who got fair market value adjustments. You didn't get it. Everybody else did. And because it's based on the 2019, 20, and 21 sales report that I'm going to get to, and that's what the calculation required. Also, she says in here that this publication is made as required by 35 ILCS 200/12-10. So she's telling you that provision of the law is why she gave you notice for an assessed value change for 2022. And she's giving you that notice in the newspaper on July 25th of 2023. Well, the next one, right? Remember this provision of the law that I showed you? 35 ILCS 200/12-10. That's the provision that's in Georgia's notice that she says is why she's telling you on July 25th of 23, what your assessment's going to be for 2022. She cites the correct provision of the law. But guess what? Go back down to the bottom to where it says the publication shall be made on or before December 31st of that year, the reassessment year, and that would have been 12/31/22. So the question you should ask yourself, well, if I was supposed to get notice in 2022 by 12/31, even if it was a general reassessment year, which it wasn't, that's a separate legal argument. She gave me the notice 7 months late. What does that mean for me, the taxpayer? Well, go to the next slide, Ryan. Here's the law in Illinois, from the Illinois Supreme Court on down, and I'm going to read it for you. The publication requirements, that's the publication you see in the newspaper, are intended not only to give notice of the assessment to the taxpayer, but give the taxpayer an opportunity to ascertain whether assessment's excessive or disproportionate. I'm going to jump onto the bottom. Accordingly, we conclude that the publication requirements are mandatory and that they require strict and timely compliance. That's the Corzine case. There were over 400 taxpayers in the Corzine case that filed a complaint in court saying we didn't get our notices of our assessments changing until it was too late. And the court said that means the notice is invalid and your assessment can't increase. Take it back down to the last prior properly noticed increase. That's what the case law says, you guys. It's not me being Johnny Cochran giving you some legal prowess of analysis. I'm just reading the law. And the law says that the notices you got July 25th, 2023 are invalid. And as such, they can't increase your assessments. Now, if you walk in there with this slideshow to Georgia and say, Georgia, we just listened to what Tom said, and you can't raise my taxes. Do you think she's going to lower your tax assessment? In my opinion, the answer is 199.99% no. And you go, well, why not, Tom? It's illegal. Because if she does it for you, she's going to have to do it for every taxpayer in the county that got one of these notices. There's thousands of them. And so what they're likely hoping is that not enough of you file the proper appeal. Okay? They're hoping you don't appeal, guys, on grand scale. So if 100 or 200 of you appeal and they got to reduce your tax assessments, okay, do that. They're not going to do the right thing and invalidate all the assessments that they screwed up, because it's going to drive the assessed values of all these properties back down, and your taxing bodies like the school district are going to be pissed off because they lose money. So they're not going to fix this unless you sue them, you guys. My professional opinion, you can ask somebody else. You can go in there and try to get them to do what I just told you. Ain't going to happen. If you get it to happen for one of you, again, they're going to have to do it for thousands. They're just going to hope not enough of you complain. I mean, you can complain on social media. You can get over here in the right-hand column of what I'm saying and get all bent out of shape and do nothing. But at the end of the day, they don't care about that. They want to know whether or not you're going to step up and you're actually going to force their hand in a courtroom. Does that make sense? Okay. Go ahead, Brian. Remember when I told you the 17.4% number that Georgia says is that even if you're not in general reassessment and you got this equalizer, and it was based upon 2019, 20, and 21 sales? Well, here's the report that Georgia uses to do that calculation. This is a form from the Illinois Department of Revenue, 2019, 20, and 21 median levels based upon the sales. They get this information, guys, from the sales that are reported in our county on a daily basis. They track every sale. How much was it for? What was it assessed for? Was it assessed too high, assessed too low? And they do some calculations. According to the state of Illinois, the last 3 years, Bond County's averaged 29.3%. It should, in a perfect world, be 33 1/3%. So the number's too low, which, again, is suggesting very, very high level that there is an underassessment problem in Bond County. Globally, doesn't mean you. Could be, but globally. So in order to fix that, Georgia throws an equalizer on, and she calculated 17.4%. If 33 1/3 is where you're supposed to be, and 29.3 is where we're at, that's not 17.3%. It's actually around 13.7 or 8%. So if you take 33 1/3, I'm going to do the math here real quick. If you take 33.33 and divide it by 29.3, you get 13.75%. The multiplier, according to my math, should have been 13.75 and not 17.4. I've asked the assessor to explain that. The assessor's not explained it to me yet, and it is what it is. But guess what? Not only does she have to explain it to a taxpayer that asks, because I am a taxpayer in Bond County, it's required to be published on the website. Go to the next slide, Ryan. Explanation of equalization factors. You have to provide a plain English explanation of multipliers, equalizers, sorry. Plain English equalizer explanation. I just gave you a plain English equalizer explanation, and I don't get 17.4%. So I believe, unless somebody can convince me otherwise, that the equalizer of 17.4% that's got applied to everybody in Bond County is wrong. I think it's too high. I think it needs to be fixed. You think she's going to fix that? Probably not, because guess what? That's going to require a whole bunch more work. But if you're one of the taxpayers in Bond County that just got an equalizer, I would go in there and complain. Go, where's the math come from? Explain to me 17.4. If you get an explanation, call me. I'd like to hear it. Go ahead, Ryan. Okay, again, I brought this back up again. This is that notice. See the 17.4% down there? If you take 33 1/3, which is where you want to be, and you divide that by 29.3, which is where we're at, 13.75, you guys, not 17.4. You might want to go ask about that. Go ahead, Ryan. I think that's it. That it? Yeah, so that's the explanation. There's two different arguments, guys, you can make. One argument is that 2022 is not a general reassessment year because you screwed up the resolution back in 2020. It's a solid argument. The other one is that the notice that I got was untimely because I was supposed to get it by 12/31 of 22, and I got it on July 25th or 3rd of 23, 7 months late. You can't increase my tax assessment for 2022. As I've told you, you go in there and make that argument. I don't think you're going to get them to change it voluntarily because they'll have to change it for everybody. If you just go to the Board of Review, they're clueless. I don't think they'll be able to do a whole lot. In my humble opinion, you're going to have to sue them. And if you think you can sue them on your own, I encourage you to jump out there and give it a shot. If you want to go hire a lawyer, that's up to you. Hire whatever lawyer you want to hire. There's a lot of them out there that can handle what I'm talking about. Our law firm is going to file one on behalf of a ton of people. However many, I don't know how many have signed up. It doesn't matter. There's a lot of them. And we're doing it on a contingency basis, which means you don't have to pay us anything. But if we win and we get your assessment lowered, and it's all explained on the link that Ryan has over there, if we get your assessment lowered in 2022, it means your tax bill goes down. In that first year, you split the difference with us. If your taxes go down $500 because of what we did, it costs you $250 just that 1 year. Now, keep in mind, if you save $500 because of what we do, you're going to save it this year and next year and next year and the year after that. And eventually, could your taxes go up in the future? Potentially, yeah, they could. But it's going to cost you 50% the first year. Okay. Again, go find anybody to help you do that. Go try to argue the fight if you want to argue it. I think you're going to have some political difficulties getting them to agree to anything I just told you. Because keep in mind, guys, what I just explained to you, I explained to the county state's attorney and to the assessor before I went down this path. I didn't want to have to come and sue in my own county for this kind of stuff. It never excited me. I tried to get them to fix it. You know what they did? They just tried to bury it because they realized this is a really, really, really big problem. They haven't done assessments legally for 4 years. Not that just your assessment's too high or it's too low or should have been a little different. Procedurally, they've done it illegally for 4 years. This is the 4th year, 2022. I'm trying to fix it, but fixing it's going to be painful. Fixing it's going to have to require people to eat a little bit of humble pie. It's going to have to acknowledge inadequacies and incompetencies. Nobody likes to do that, right? Me, I make a mistake and I make them. I just go, I screwed up, guys. My bad. I apologize. Please forgive me. A lot of people don't have the ability to do that. And they get so insecure and scared that they just want to hide what they've screwed it up. I think that's what we're dealing with here, sadly. And that's unfortunate. So that's what we got. Okay. And Warsaw, I don't know if we're over there. I don't know if your county, I'm not analyzing your county. Procedurally, what I just explained to you, it's a state law. So yes, it's the same across the state. Whether other counties are doing that, I don't know. Freddie, that's a good question. I'm going to file this case probably the end of next week, Fred. So if people in Bond County want to join on the bandwagon, they would want to do that quickly, because by the end of next week, Frederick, that'd be when we're going to do that. Okay. All right, everybody. I am going to the 4-H auction. Going to go buy a pig or a sheep or something from one of those little babies that's worked all year. Talk to you later. I